I won't need to project my voice. I have the microphone on. You can probably hear me. Anyhow, I'm Shamit Sagar. I'm a professor here at UWA, and I'm also the director of the UWA Public Policy Institute. So welcome. I'd like to acknowledge that we are on the land, traditional land of the Noongar people, and therefore I pay my respects to their elders, past, present, and future. Two words while I've got the platform and I've got the microphone about the Institute. In late 2018, this university, alongside many other research-intensive universities, established the Public Policy Institute in an effort to make sure that world-class research was put into the hands of decision makers in a timely way and in a way that is translated and fit for use, fit for purpose. So the Institute does many, many things. I'm not going to clog up the time at the start of this event, but this is the most recent report we published in the early part of this year, looking at mid-century policy options in different areas to do with the economy, environment, as well as people and our relationship with the region. The Institute is very proud to sort of host and co-host this event this evening. I think it's a collaboration between ourselves, the law school, and the electoral registration network here at WA. I'm not going to sort of clog up and preface your remarks other than to say one thing, which is my observation that although lobbying itself is something that we're going to focus upon and sort of the options that are available in terms of reform, it's probably helpful as a discipline to look at what I would describe as constitutional regulation around all different aspects that range from how do we get people informed and participating in the system, notwithstanding compulsory voting. How do we ensure that campaign finances remain clean? Indeed, do we know campaign finances remain clean? And might ensure they remain that way. All the way through to the establishment of the new Anti-Corruption Commission at national level and all the issues that leads to. Many countries tend to compare their notes between those constitutional regulators and ensure that they're trying to move in unison and certainly ensure that they are cognizant of what one another is doing. So lobbying, I think, is a case in point in relation to that. But I look forward to your comments in detail as you're going to share them this evening. Your chair for the actual evening is Sarah Murray, a colleague and a fellow of the Institute. And Sarah's going to introduce our speaker and moderate the questions thereafter. Thank you very much.
Thank you very much, Shannon. I really, for that introduction. I'd just like to reiterate that we're bringing this seminar today on behalf of the UWA Law School, Public Policy Institute, and the WA chapter of the Electoral Regulation Research Network. And I know much of that network are joining us remotely this evening. For many people, it's this evening. So thank you very much and for being with us for this really, really important discussion. And what I'm really looking forward to with this seminar is really hearing from Associate Professor Yi-Fui Ng about how we can think about lobbying regulation and how we can make it more effective. I think particularly thinking about not only the targets of regulation, but also its breadth, as well as thinking about what we can learn from the experience of lobbying regulation in Australia so far. And I think that really gives us a chance to think about what's working, what's not working. The plan is that we're going to hear from Yi-Fui first. We're then going to have a bit of a Q&A where I'm going to ask Yi-Fui some really, really hard questions. And then we're going to open the floor for both attendees online and those here in person, and we can all ask some questions and explore lobbying regulation in a little bit more depth. But to help us answer some of these questions, I just want to introduce you all to Associate Professor Yi-Fui Ng. She's the Acting Director of the Australian Centre for Justice Innovation at Monash University, as well as being a 2021 to 22 Fulbright Scholar, having recently returned from the States. Her research centres on the intersection between public law and politics, particularly focusing on executive accountability. So please, if we could all make Yi-Fui welcome.
Okay, good evening, everybody, and thank you to Sarah Murray for organising this talk and hosting me here. This is my first time in Perth, and I have concluded the campus is beautiful, the weather is beautiful, the beaches are awesome. So I'm really, really glad to be here today. So I got interested in this topic of lobbying regulation from my time in the Prime Minister's Department, where I saw all these different interest groups write to the Prime Minister, from the Smokeless Tobacco Action Group to all these random people were approaching the Prime Minister, and it got me interested in who gets the access to all these very top important political figures. And I was also working on the Henry Tax Review, which was the biggest root and branch tax review for 30 to 50 years. And one of the quite sensible proposals was to impose or abolish the super profits that the miners were getting. Impose a tax on the miners. And I saw a huge campaign launched by the mining lobby opposing that, front pages of all the papers, they bought all of that. And the government backed down immediately. So I saw a quite sensible policy reform being completely shut down by a lobby group. So that got me very interested in how do we regulate the interest of broader society versus the interest of people who can pay for all these very expensive lobbies to further their cause. And so over the past 30 years, commercial lobbying in Australia has grown from a very small industry of a few hundred employees to become a lucrative multi-billion-dollar industry. So third-party or commercial lobbyists are paid professionals who are engaged by clients to influence public officials on behalf of their employer, while in-house lobbyists are those who are hired by their employers to influence public officials on behalf of their employer. A Senate committee in 2008 heard evidence that there are about 4,000 lobbyists in the broader community. If in-house lobbyists are included, the estimate in 2012 indicates that there are about 5,000 lobbyists in the system. However, our federal lobbyist register shows a much lower number because it only applies to third-party lobbyists, which only account for 20% of the lobbyist population. So as of December 2022, the federal lobbyist register indicates that 675 lobbyists are employed by 321 firms. And of the lobbyists, 38% are former government representatives that are former ministers, former politicians, senior public servants, and ministerial advisors. So this shows that there's a revolving door between government and lobbyists due to the extensive and beneficial networks that are developed by all these public officials. And beyond this impressionistic sketch, there is very little clarity as to precisely how many lobbyists there are, how they are structured, and how they operate. So the opaqueness about third-party and in-house lobbyists in Australia points to its very vexed role. On the one hand, there is no doubt that lobbying is essential to the proper working of democracies. As the Western Australian Corruption and Crime Commission said, the right to influence government decisions is a fundamental tenet that underpins our system of government and a form of political participation that makes the wheel of government turn. When managed according to the public interest, lobbying has not only a legitimate, but a very important role to play in our democratic process. At the same time, democracies can also be undermined by lobbying. Lobbying may give special advantages to vocal vested interests with negotiations that are carried out behind closed doors and overriding the public interest in government decision-making. In the 2020 Victorian IBEX Operation Send-On, it was revealed that the lobbyists had funneled bags of cash totaling more than $100,000 from a property developer to a councillor under the guise of sham transactions. In 2019, New South Wales ICAC launched an inquiry into lobbying regulation called Operation Eclipse, as it identified inappropriate lobbying as a potential corruption risk following its previous lobbying investigation, Operation Halifax, in 2010. And these investigations sit alongside notorious lobbying scandals overseas, such as Jack Abramoff in the United States, who lobbied on behalf of Native American tribes seeking to establish gambling on reservations, where he grossly overcharged his clients. And in one case, he secretly orchestrated lobbyists lobbying against his own clients to force the clients to pay more for his lobbying services. Abramoff was sentenced to 6 years imprisonment after pleading guilty to mail fraud, tax evasion, and conspiracy to bribe public officials. In Europe, there was the Cash for Amendments scandal, where it was revealed that 4 members of the European Parliament were videotaped agreeing to bribes in exchange for official favors from journalists who masqueraded as lobbyists. So together, these explosive scandals show that the regulation of political lobbying is a global corruption challenge for governments. And I should say at this point that I wrote the discussion paper with Joo Chong Tam for Operation Eclipse, so the ICAC investigation. And I appeared as an expert witness for that investigation as well. And I also appeared as an expert witness for IBEX Operation Sendon. It was quite fun to read the transcripts. Like, I don't know where this money came from. Maybe the casino, you know. Selective amnesia is quite rife when you read transcripts from that. So how has lobbying regulation developed in Australia? So the first ever lobbying regulation in Australia was at the Commonwealth level in 1983 in response to a scandal where prominent lobbyist David Kuhn established a relationship with Soviet diplomat Valery Ivanov, who turned out to be a spy for the Soviet government. This early regulation of lobbying was minimalist, involving a voluntary private register without any enforcement. So the secretive nature of this scheme, combined with the lack of enforcement, meant that it was essentially up to the lobbyists and government officials to individually self-regulate their own behavior. Following this, in the second phase of executive regulation of lobbying, the executive regulation of lobbying was introduced, which involved lobbyist codes of conduct and public lobbyist register that applied to third-party lobbyists. And this new form of regulation was sparked in Western Australia in response to a scandal involving former Premier Brian Burke, his former ministerial colleague Julian Grill, and former Senator Noel Crichton-Brown. So these were lobbyists with an extensive network of ministerial, party, and bureaucratic contacts. And they exploited these contacts to obtain confidential information and influence government decisions for the purposes of their lobbying activities. And these activities led to findings of misconduct in the Corruption and Crime Commission of Western Australia and prompted the resignation of 4 ministers. So this executive regulation was adopted wholesale by the Commonwealth and all the other states. However, this regulation only applied to third-party lobbyists and were executive schemes, that is, they were not legislated. And they also lacked effective enforcement mechanisms. Finally, in the legislative regulation phase, there was a fracturing and disaggregation of lobbying schemes across the jurisdictions, with each jurisdiction adopting their own regulatory framework. So what we can see from the new legislative models is a general trend towards more stringent regulation of lobbying. So there are 3 main models of legislative regulation. The codification model in South Australia and Western Australia that merely replicates the existing executive scheme, but with tougher penalties. There's also the selective model at the federal level that only targets those who lobby on behalf of foreign principals. Finally, there are the innovative models in Queensland and New South Wales that include new structural or operational innovations. Victoria and Tasmania have lagged behind and remain with schemes of executive regulation, although Victoria has introduced an additional register for in-house government affairs directors. So legislative regulation in New South Wales was triggered following the resignation of the Premier and 10 members of Parliament over the ICAC investigations Operation Spicer, which also led to former Minister Obeid to be sentenced to 5 years imprisonment for misconduct in public office. The indirect trigger for the Queensland legislative regulation was the explosive Fitzgerald inquiry that resonated through the states for several decades, leading to wide-scale integrity reforms. By contrast, the more lackluster codification of the executive schemes in Western Australia and South Australia did not reflect any scandals and therefore did not introduce any radical changes to the pre-existing schemes. So based on these trends, if further scandal and controversy erupts in the jurisdiction, we might expect to see further regulation and further tightening of the lobbying rules. So the main features of the legislative scheme are largely similar to the previous phase of executive regulation. They involve lobbyist codes of conduct and the public lobbyist register. So only third-party lobbyists are required to register, thus excluding the majority of the lobbyist population. Following Operation Eclipse, the New South Wales government has announced that it will extend its laws to require in-house lobbyists to register as well, making it the most comprehensive Australian jurisdiction in the scope of regulation. So Queensland and New South Wales have also incorporated enhanced disclosure provisions compared to other jurisdictions. So in Queensland, third-party lobbyists are required to inform the Integrity Commissioner monthly about the details of every lobbying contact, including the name of the lobbyist, whether the lobbyist complied with the code of conduct, the date of the contact and the client of the lobbyist, the name of the government official or opposition representative, and the purpose of the contact. So this information is made publicly available on the Integrity Commissioner website. And this disclosure regime thus promotes transparency in publishing details of each and every lobbying contact with public officials, which is absent in the other jurisdictions. In addition, ministerial diaries are published in Queensland and New South Wales, providing information about the name of the organization or person, the purpose of the meeting as well. However, the quality of diary disclosures in Australia has been very poor, with some entries simply listing other or meeting, which doesn't provide any illumination about the subject matter discussed or the real purpose of the meeting. New South Wales has recently announced that it will extend diary disclosures to members of Parliament as well, so MPs as well as ministers. In New South Wales, the compliance regime has been strengthened. So this scheme is administered and enforced now by the New South Wales Electoral Commission. The Commission has a range of administrative sanctions at its disposal. It may cancel or suspend the registration of a lobbyist if they breach the Act or the Code, if they fail to update their contact information on the register. So the New South Wales scheme also provides for a novel compliance mechanism. The Commission is required to maintain a lobbyist watch list, which is a public document published on the same website as the lobbyist register that lists any lobbyists who have breached the Act or the Code. So this is a pioneering mechanism to basically name and shame all these errant lobbyists. Lobbyists on this watch list are also subject to stricter controls. So a Premier's memorandum provided that the lobbying activities of those on the watch list are subject to stricter meeting protocols, that is having 2 government officials present during any communication with the lobbyist. One of those officials is required to take notes of any communications with the lobbyists and provide the notes to the agency head. More recently, the New South Wales government has announced that it will introduce Australia's first dedicated lobbying commissioner. So there'll be a commissioner dedicated to lobbying. So therefore, Queensland and New South Wales have gone the furthest in regulating lobbying in the Australian Federation. So with this snapshot of how Australian jurisdictions are currently regulating lobbying, the next question is, how should we ideally regulate lobbying? So what's the best practice method of regulating lobbying? I argue that the methods deployed to regulate lobbying have to take into account the purposes of the regulation. So there are a few main purposes for regulating lobbying. The first is to prevent corrupt behavior by the lobbyists and public officials, so those bags of cash being exchanged. The second purpose is a broader notion of political equality in ensuring the fairness of government policy making, in ensuring the transparency in the disclosure of lobbying activities. So this is aimed at reducing the incidence of secret lobbying by vested interests and reducing the risk of regulatory capture by government. So the prevention of corruption and increase in transparency leads then to the third purpose of improving the quality of government decision-making by ensuring that government decisions are made according to merit rather than skewed towards narrow sectional interests. And this in turn will increase public confidence in the integrity of political institutions. So governments seeking to regulate the market of access and influence through lobbying have several regulatory options in their toolkit. The most radical approach is to ban the activity entirely, either for ethical, moral, strategic, or public interest grounds. However, given the widely acknowledged importance of lobbying as part of the democratic process and the need for elected representatives to consult with their constituents on government policy, it's not appropriate for government to take a blanket ban and blanket prohibitive approach to lobbying. Rather, it's only the lobbying activities that are most likely to lead to quid pro quo corruption that should be prohibited. That is where payment is made directly in exchange for an official act. For instance, bans on the ability of lobbyists to receive success fees that exist in certain Australian jurisdictions can be justified. This is because fees contingent on success they give lobbyists an incentive to engage in potentially unethical or corrupt behavior in order to secure their remuneration. In addition, in a number of Australian jurisdictions, members of parliament are banned from receiving remuneration for parliamentary speeches, questions, motions, or the introduction or amendment of bills. The rationale for this ban is that it enables interest groups to use money to monopolize a scarce parliamentary resource. And this may lead to a conflict of interest between the MP's personal financial advancement and the public interest. So this is illustrated by the repeated cash for question scandals that have engulfed the MPs in the United Kingdom. These scandals have resulted in public consternation and parliamentary inquiries. Salutary examples of MPs being unduly influenced to use their parliamentary duties to secure personal pecuniary benefit. In some jurisdictions, such as the United States and Canada, but not in Australia, there's also a ban on lobbyists giving gifts to government officials. So this is seen to unduly sway public officials to be more receptive to the entreaties of these lobbyists. In addition, there are bans on post-separation employment for government officials, both in Australia and overseas. So where certain government officials, such as ministers, ministerial advisors, and senior public servants are prohibited from working as lobbyists in their portfolio area for a certain period. Tends to be 12 to 18 months in Australia, 5 years in Canada. So these bans exist in Australia, but they are not well enforced. The post-separation bans are to prevent corruption, that is to combat the use of confidential information by former government officials. It also reduces the risk that well-funded industry groups may approach ministers while they're still in office with promises of lucrative positions after politics if their grants or applications are approved. So these bans on specific lobbying activities seek to reduce the risk of the narrow quid pro quo corruption, where public officials receive a direct or indirect benefit in order to advance the causes of vested interests, which then detracts from the broader public interest and the integrity and legitimacy of democratic governance. Besides the bans on the most pernicious lobbying activities that are likely to lead to quid pro quo corruption, the next and most prevalent regulatory approach is to provide increased transparency of lobbying activities. As the saying goes, sunlight is the best disinfectant. Transparency requirements take the form of public registers of lobbyists and varying levels of disclosure requirements of lobbying activities across the jurisdictions. Increased transparency will enhance the fairness of the democratic system by correcting the information asymmetry that may develop where lobbyists can hide their activities behind closed doors. This goes to the broader concept of clientelism referred to by the High Court in the joint judgment of McCloy, which is the danger that government officials will decide issues not on their merits or the desires of their constituencies, but according to the wishes of certain vested interests. The requirement to disclose lobbying contacts as implemented in Queensland, as well as Canada and Scotland, or the disclosures of ministerial diaries as required in New South Wales and Queensland, enables civil society and opposing interest groups to be aware about who is lobbying government and for what purpose. And this will enable other interest groups to engage in counter lobbying and put forward their opposing views, which will then furnish government officials with a more diverse range of perspectives in informing their decision making. As a result, the quality and integrity of government policy making and decision making will be enhanced. Other jurisdictions, such as the United States, go further, and they require disclosure of political donations by lobbyists. And that's an acknowledgement of the significance of money in politics, which you raised before, where generous donations may mean that elected representatives are more positively predisposed to their benefactors. So given this regulatory framework, what can we make of the effectiveness of lobbying regulation in Australia? So the coverage of lobbyists required to register in Australia, apart from future changes in New South Wales, is confined to third-party lobbyists, which only comprises 20% of the lobbyist population. This means that a whole large proportion of lobbyists are not covered by the regulation at all, such as those who operate in-house as employees. And such restrictive coverage fails to provide proper transparency for government decision-making in terms of lobbying by repeat players. By contrast, comparable jurisdictions that have a long history of regulating lobbyists, such as Canada and the United States, cover both third-party and in-house lobbyists. The question of who should be covered by lobbying regulation goes to the normative question of significance. That is, whether they undertake a significant amount of activity that warrants closer public scrutiny. So the ideal regulatory coverage is to achieve a Goldilocks level where the regulatory net is neither cast too broadly nor too narrowly. it should be just right. So if the coverage of lobbyists is too narrow, the regulation will not be effective to achieve the purposes of political equality and the prevention of corruption. And it doesn't, because it won't encompass those who undertake significant lobbying activities. If too many individuals and groups are caught by the regulatory framework, this could include those that approach government for minor or personal matters that are not of interest to the wider public. And that creates a burden then on the big players, and it then obscures who the major players are. So to confine the categories of lobbyists to significant players, the coverage of lobbyists can be narrowed based on the intensity of lobbying activity. For instance, the number or percentage of time spent lobbying, or the amount of money or income received from lobbying activities. For instance, in the United States, there are two main thresholds that need to be made before the requirement to register is triggered. The first is based on the level of lobbying activities, where a person is only required to register if they make more than one lobbying contact for the client, and the lobbying activities consume at least 20% of that person's time for that client over a 3-month period. The other requirement is based on differential financial thresholds for third-party and in-house lobbyists, based on how much they earn and how much they spend on lobbying activities. Another approach could be segmented regulation based on risk, such as adopting a risk assessment framework to assess whether each person should register. Alternatively, higher risk industries could be determined, such as property developers or the gambling industries, which are then subject to more onerous regulation. This was the approach taken for electoral funding in New South Wales, where property developers, tobacco businesses, and the liquor and gambling industries are banned from making political donations. Another option is exempting certain low-risk industries from regulations, such as charities or not-for-profit organizations. A further issue is the level of disclosure that is required of the lobbyist. Again, there needs to be a Goldilocks level of balance between obtaining meaningful information that advances the purposes of transparency versus requiring too much information. If there is an insufficient level of disclosure, then the purposes of lobbying regulation are not realized, and the ideals of political equality and leveling the playing field, as well as preventing corruption, are not achieved. On the other hand, an excessive level of disclosure may create a large administrative burden that will disproportionately impact on poorly funded individuals, not-for-profit organizations, and community advocates, who may find it more difficult to resource additional compliance requirements. This may then have a chilling effect on the willingness of individuals or groups to approach government officials. At the same time, government officials may also be more reluctant to meet with individuals and groups due to the regulatory red tape and the onerous requirements that are involved. So the level of disclosure of lobbying activity required in most Australian jurisdictions is dismal. With the exception of New South Wales and Queensland, the only disclosure that is required is the name and contact details of the lobbyist and the client that they are representing. There is thus a complete vacuum of knowledge as to when lobbyists are contacting government officials and over what policy issues. In New South Wales and Queensland, there is the disclosure of ministerial diaries, which does provide some visibility about who the ministers are meeting with and the broad subject matter of the meeting. However, other logical targets for lobbyists, such as ministerial advisors, public servants, and members of parliament, are not covered by this form of regulation. Queensland has the most comprehensive regulation in this regard, with a requirement to disclose all lobbying contacts. So every time a lobbyist contacts a public official, such as in Canada and Scotland as well. However, in both Queensland and New South Wales, the quality of disclosure has been very poor, with some lobbyists merely listing the reason of their lobbyist contact as other. This can be contrasted with the lobbyist register in Scotland, where the lobbyists have provided extensive disclosure of their activities, including precisely who they met, the subject matter, identifying which legislation they are lobbying in relation to, and what they were hoping to achieve with that meeting. Diary disclosures in Australia should be therefore required to specify the subject matter, whether it relates to any legislative bills, grants, or contracts, which should also be specified. Finally, compliance and enforcement remain key to a successful system of lobbying regulation. The Guardian has reported very poor enforcement efforts by Australian regulators, where not a single lobbyist was punished for breaching the rules in the 5 years federally, or in Victoria, Western Australia, Queensland, and South Australia. In 2018, the Commonwealth Auditor General found that the Prime Minister's Department, which then oversaw the Federal Lobbyist Register, had not suspended or removed the registration of a single lobbyist since 2013, despite identifying at least 11 possible breaches. The Auditor General recommended that the Prime Minister's Department assess risk to compliance with the code and provide advice on the ongoing sufficiency of the management compliance framework. The Secretary of the Prime Minister's Department responded that they considered their role to be merely administrative, not regulatory. And this weak enforcement points to the need for an independent regulator administering a statutory scheme, rather than the responsibility residing within a government department, which does not have sufficient independence from the core executive. By contrast to all the other Australian jurisdictions, the New South Wales Electoral Commission became responsible for regulating lobbyists in December 2014. And since then, it has undertaken a number of compliance actions where potential breaches of the lobbyist codes of conduct were subject to a compliance review or investigation. In addition, a number of registered lobbyists received warnings, had their registrations suspended or cancelled, or were placed on the watch list for failing to confirm their registered details were up to date. So we see more compliance and enforcement efforts in the hands of the Independent Electoral Commission. Some overseas lobbying regimes have a more systematic monitoring and compliance regime through a program of proactive audit investigations. For instance, the Canadian Office of the Commissioner of Lobbying conducts monitoring and compliance verification activities to ensure that registrable lobbying activity is properly reported and information provided by lobbyists is thorough, accurate, and complete. Suspected and alleged non-compliance with the Canadian Lobbying Act and the Lobbyist Code of Conduct is reviewed, and formal investigations are undertaken to ensure that lobbying activities are ethical and transparent. So the Commissioner presents findings and conclusions in its report of investigation, which is then tabled in the Canadian Parliament. So in the United States, the compliant monitoring approach includes the Government Accountability Office conducting annual review of the lobbyist compliance with disclosure requirements. So to conclude, as part of this impetus to improve the decline in public faith in democracy and political institutions in Australia, governments should seek to regulate the strong influence of vested interest and influence peddlers that can drown out other less well-resourced and well-connected voices within our democracy. We should bring to light what is happening behind closed doors, in the shadowy rooms behind the shops and beneath the stairs, linking a network of wires and pipes and pulleys and pistons and counterweights to power. And reform of lobbying regulation in Australia to enhance the scope of its coverage, and the level of disclosure of lobbying activity will shine a light of transparency into an area that is currently hidden in the shadows. It will reduce the risk of corruption by lobbyists and public officials, and ultimately promote the democratic norms of political equality and fairness. So thank you very much.
Well, I think what we're going to do now is I get the lucky position of getting to ask you some questions, Yip-Wei, which is, a challenge because you've covered so much of the questions I have, which is wonderful. And I think, what I'm thinking is I've got some things I'm going to ask, and then I'd really like to open the floor and get some thoughts and questions from others and from those online, which Rebecca will facilitate. If you've got a microphone there for that too, wonderful. So I guess what I'm interested in is, you talked a lot about, what are the clear benefits of lobbying for our democratic system, but also obviously that the obvious threats or risks that lobbying can present. I mean, how well do you think Australia is balancing these competing interests?
It's not been well regulated to date because the regulation of lobbyists just covers third-party lobbyists, which is 20% of the lobbyist population. So, 80% of lobbyists remain unregulated. New South Wales has just announced the changes where they will broaden the regulatory net. And the level of disclosure has been poor as well, in terms of, the ideal model would be to disclose when people are lobbying. So if we know that the mining industry is meeting with the environmental minister 20 times this month, if all those contacts are disclosed, then the environmental groups know and they can engage in counter lobbying. So this idea that we should know who is lobbying government and when, I think is a very important one. And disclosure of lobbyists contacts is important for that. Either that or disclosure of ministerial diaries, or both in conjunction, as we see in New South Wales.
Yeah, okay. And why is it that, obviously you say that New South Wales is shifting to have broader regulation beyond just those third-party lobbyists? Why do you think that Australia generally in most jurisdictions has been quite slow to do that? Is that partly because of the difficulty of, as you say, determining how you identify who is a lobbyist that comes within that regulatory net, or are there other factors, do you think, at play?
Well, what we see is enhanced regulation. Every time there's a scandal or controversy, then there's more regulation in that sphere. So in New South Wales, we saw several scandals. Also, the New South Wales ICAC. So the regulators have been very active in bringing the issue to light. So Operation Eclipse was the catalyst that led to the latest round of reforms that said, okay, we're going to do not just third-party lobbyists, we're going to cover in-house lobbyists as well. We'll disclose MP diaries, as well as ministers will introduce a dedicated lobbying commissioner. So this is the action of the regulators pushing for reform, and I was pleased to be part of that push as well. Yeah.
So it really kind of ties into this idea of it being kind of a responsive approach in terms of really realising that there's a gap, but not, rather than kind of being front-end normative design of what might be best.
I think so. And I think the regulators are seeing this as a big issue. So I spoke at the Integrity Summit with a whole bunch of anti-corruption commissioners, integrity commissioners, and the senior public servants. And they picked lobbying regulation as a key issue for that first ever Integrity Summit. So I think it's becoming more front foot on the agenda as we see, the bags of money being exchanged between lobbyists funneled to the councillors. That's front page news. That's a problem.
Don't see the money bags.
No.
As the case may be.
Yeah, exactly.
Yeah, okay. To what extent, I mean, you talk about, this kind of becoming kind of a more front and centre as an issue. To what extent do you think this is seen by public servants as almost a form of protection, you know, in terms of it actually protects them the more there is regulation in terms of being seen to be being influenced, I guess?
Yeah, as a former public servant who has escaped, I can say that the public service tends to be extremely risk averse. So anything that will protect them, they would like, but they also like to, well, this is the overgeneralization, but the urge is to hide the dirty laundry. So yeah, so I think there are two imperatives there, that urge to hide things, but also that urge to protect themselves.
Okay.
Yeah.
No, that makes a lot of sense. And do you think that, you know, you talk about the difference between sort of departmental supervision and, you know, independent statutory agencies, or say the New South Wales model where the regulation happens through the Electoral Commission?
Yeah.
And, you know, obviously with New South Wales undertaking further reforms, is that a heavy resource allocation for them? In terms of the amount of time it's taking away from other Electoral Commission work? I mean, is this seen or is it being appropriately funded because of the significance of lobbying regulation for that agency?
Yeah, that's a really good point. And I do have to give a shout out to the New South Wales Electoral Commission. They have done an amazing job in terms of compliance and auditing and enforcement efforts, both in terms of political donations and, you know, withholding public funding from parties to breach the rules. And also, yeah, this lobbying regime, they've taken it on the front foot, and they're actually, creating a proactive regime of monitoring and auditing and enforcement. But yeah, I think you're right. Adequate funding of the commission is very important. So what we saw in Queensland is the Integrity Commissioner has a range of different functions, including lobbying. And one year they just defunded the lobbying part, and then the commissioner just reduced their functions rather than expanded it because they just didn't have the money. So you're quite right that it's quite susceptible if you don't resource and fund it appropriately. And in this sense, the New South Wales model of having a dedicated lobbying commissioner is good because that's their function. But you know, that doesn't stop hostile governments. We've seen the Commonwealth Ombudsman being defunded to the extent that he had to close off his office and work from home, you know. So yeah, there's always that issue of funding in terms of our independent oversight bodies and governments who don't like being scrutinized.
The final question I might ask then is, why do you think we've seen such limited enforcement?
Well, because I think most, from executive regulation, the enforcers were, you know, the Department of Premier, Cabinet, the Prime Minister's Department. They just see their role as administrative, as the Secretary said. So we're just processing forms. We're not there to go out and regulate and prosecute and audit and ensure compliance. Whereas the regulator's mindset is quite different. Like the, you know, independent commissioners, the ombudsman, they feel like their remit is to go out there and make sure that the integrity system is working correctly, that they are looking for the rules to be followed. Yeah.
No. That makes a lot of sense, but it also shows the complexity of this issue, doesn't it? Yeah, which is right. Well, I think we might open the floor just to anyone in the room who might have a question for you, or to someone online. Jacinta, would you like to start? I'm just thinking about the microphone. Do we need to move something up there, Rebecca? Or?
Maybe just
yeah, sure.
You mentioned that you've just come back from the US, or Sarah mentioned, and so I'm assuming you were there to study the lobbying, to some extent, of the lobbying framework in the US. And you could also mention before that lobbying regulation is far more developed in the US. But yet, I don't know anything about the US in that respect, but yet we hear, for example, the powers that lobbyists still have in the political process. Most obvious one was helping the gun lobby, and really still having that ability to stymie or to prevent what we might think of as a democratic process. So if they have a developed lobby regulatory framework, why are those, and I know it's a huge question, but why are there still those difficulties with the lobbying industry? Is it something about that framework you would suggest we do differently in Australia, or why do you think it's still not solving the problem?
Yeah, that's an excellent question. Actually, my Fulbright was on automated government decision making, so robo that kind of issues. And yeah, I'm writing a book comparing automated government decision making in the US, Australia, and the UK. But I did, while I was doing all my meetings, managed to fit in a meeting with one of the major academics in lobbying regulation, James Thurber, Professor James Thurber, who is in Washington, has researched lobbying for decades. And I guess one point to make is that, you know, the right to bear arms is in the US Constitution, so that and a lot of the US rights stem from their constitution, like due process and so forth. So that's one point of difference, and that shows why the gun lobby is so strong. It's constitutionally entrenched. We don't have similar issues here in terms of the entrenchment of the right to bear arms. So I think the gun lobby derives its strength from that, oh, you know, it's protected in our constitution, it's our right. It's that kind of rhetoric that leads the gun lobby to be so strong there. But they certainly do have very sophisticated regulation. They've been regulating lobbyists since the 1950s, both the Foreign Agent Registration Scheme and also their just general lobbying act. And we've seen very sophisticated regulation that the level of disclosure is a lot higher in terms of you have to disclose, the lobbyists have to disclose their donations, how much they spend in lobbying, you know, whining and dining all these people. So it's a really sophisticated regime, and the Canadian regime as well dates from the 1950s. So I think we can learn a lot from that. And yeah, and it seems like they're, you know, tweaking now at the edges to improve all these different things. Like he's still not happy with the level of regulation, even though it's super high. So I think, like, you know, it's always the work in progress that we keep trying to reform. And yeah, you're right that the gun lobby in the US is really strong, but I think that's a function of that constitution entrenching that as a right. Yeah.
Just a comment, if I may. From a minister's point of view, you want to know who you're talking to. That's front and centre. And when you talk about people who are in-house, you call them lobbyists, I wouldn't necessarily. They will invariably be board members, lawyers, accountants, or technical specialists presenting the case of their company or organisation. There's no problem with that from a minister's point of view. That's fine. You know who you're talking to. The issue comes with the third party. I think you could make that point. But again, it's quite a bureaucratic process to monitor lobbyists, and you know, there's an involvement in that. But for example, in Western Australia, the supervision of the legislation is handled by the Public Sector Commissioner position that was established independently of the executive of government. And the cases that might occur, and I think they're pretty rare, but when they do occur, they may just be simply you know, poor sort of administrative behaviour, and the Public Sector Commissioner will handle that. That'll be a functional thing within the bureaucracy. It may be improper, unethical conduct. The corruption, that'll go to the Corruption and Crime Commission. It may be something that clearly is illegal, and that goes directly to the police. So, you know, we don't really need, in my view, another layer on top of that. And where there has been severe, serious illegal or corrupt activity, people have gone to jail in this state. And that's the way it should be. Instead of another structure, you're just going to go around and around again. As to ministerial diaries, I don't agree with that. You can have all sorts of situations, people coming about domestic violence situations, about criminal activity, about intimidation, personal health data and so on. You cannot expect in a democracy for people's details and contacts with ministers, it might be mental health issues more broadly, to be available publicly. I just don't agree with that at all. And I think you've got to, and ministers and prime ministers and premiers rely on their chiefs of staff and the structure within the bureaucracies to deal with that. So, you get some bad eggs, there's no doubt about that, I'm not denying that, but you don't get many of them. And the cases in historically, I guess, in New South Wales, Queensland, Victoria, and you mentioned the Brian Burke era in this state, they are extreme, not general practice within government.
Yeah, I completely agree that, by and large, people who are in government, in the public service, ministers, politicians, they all want to do the right thing. And there are, of course, the very few who don't and, are corrupt and disrupt the system. But, by and large, you're right. Like, everyone is trying to do the best for the country, for the state. And you're right that there is an interlocking integrity framework that we have in place. So like the public sector commissioner would be the equivalent of the New South Wales Electoral Commission. So they'll, regulate the lobbyist register and so forth. And anything that's untoward can be forwarded to the anti-corruption commissions or corruption and crime commission, and that's correct. And if there's criminal activity, it goes to the police. So this shows the strength of our system, I think, that we do have, an interlocking framework where different agencies or commissions deal with the different aspects of differing level of severity. So I think it's completely right that each of them have their own functions, and that's fine. As to the the mom and dads approaching ministers, I think that's right too. So my proposal was on the registration side for lobbyists, just those who undertake a significant amount of activity. So that would exclude, moms and dads approaching ministers for personal matters.
And lobbyists.
Pardon?
People will go to lobbyists and lawyers and others to represent their personal circumstances. It happens all the time.
Yeah, so yeah, if it reaches that financial threshold or the amount of time spent, they would be required to register. So that doesn't overly burden the small people who do want to approach their minister for legitimate issues or their personal issues. So yeah, that's sort of my recommendation in terms of not covering too many people. And yeah, of course, ministerial diaries, when they're disclosed, they don't need to disclose personal or sensitive matters. It's more, they're meeting with the mining lobby or the environmental lobby, that kind of thing, that is appropriate to disclose.
Time just for one more question.
Just on the in-house lobby, how would you describe that? Is it, say, like government relations teams in, okay.
Yeah.
And how prevalent would that be in a state like WA? I imagine, because our mining companies here have huge government relations teams. So,
yeah, so they come by many labels like government relations team, government affairs, or public relations. So there's all these different labels. But yeah, they tend to undertake those activities of advancing the interests of their employers, meeting with all the politicians and public servants. There wasn't a specific study on WA, but I would say, the mining lobby would be quite strong. Maybe the business lobby is quite strong, things like that. So the estimate by the Queensland Integrity Commissioner was that 80% of lobbyists are in-house lobbyists and only 20% were third-party lobbyists.
You something you want to add there? Yes, please. Go for it.
As a former lobbyist, I think, there is this issue of an arms race that you sort of activate there, and I think it would be wrong to characterise it in an asynchronous way about, the mining lobby or the business lobby. That there's been a real development in trying to influence public policy through groups like GetUp and other very clever campaigns, very well-funded campaigns, very distributed in the way they go about it. And I think there's, I certainly agree with the first point around the egregious use of a lobbyist in a corrupt way is something that is unsustainable, but the
democratisation of influence, if you like, on politicians is on a spectrum which goes right back to their pre-selection committees, or in the case of the Labor Party, right back into the unions. And to be in the room when somebody either on the pre-selection committee or in the union just picks up the phone, brings the minister and says, "This is what I want to happen," isn't necessarily corrupt, but it's certainly not what a person in the street can do. And it's there's a certain organisations invest in creating that level of influence over a period of time.
Yeah, for sure. There's definitely, very well-resourced groups on the left as well as the right and the center. So, this regulation would cover all of the groups, like whatever the ideology is. So, you're quite right that there are, and the idea is that once you know this group is getting a lot of meetings, the other group can mobilize and then counter lobby, then the politician gets a range of ideas and range of opinions. So that's the theory behind it.
Well, maybe one sort of last thought just to finish off our seminar this evening. I think we're probably hitting our time. If you had the ability to change one thing tomorrow about lobbying regulation in this country, I don't know, along your Goldilocks analogy maybe, what do you think that might be, Yifei?
Oh, I can cheat and do two-ish. So
We'll allow that.
So covering the whole of the lobbying population. So like third party in-house, and also the level of disclosure. So disclosure of each lobbying contact, alongside the disclosure of ministerial diaries. Yeah.
So all about letting the sunlight in every way you can, I think.
Yeah. I had a co-author who was grumpy when I said sunlight is the best disinfectant. He's like, this is a cliche, take it out. So, but I can't help it. It is, transparency does, promote public discourse and the ability for groups to know what's going on and the other groups to mobilize as well.
No, that's wonderful. Look, thank you so much for sharing your research in this area with us this evening. And I know that I think that we will share afterwards some of your work with attendees so people can follow some of these issues a bit further. But if everyone could just join me in thanking Yifei for coming all this way. Thank you.